Matthew Harris, the creator of Unbreaded. And if you guys don't remember Unbreaded, Matthew Harris was a philosophy doctorate student at the University of UCLA. And he kind of lost his fucking mind. He's of that age when you're a male getting through your 20s is one of the biggest times for schizophrenia to develop. Once you get to your 30s as a male, you're kind of safe and clear till you turn about 60. And then schizophrenia does have another chance of reoccurring statistically. It's not as bad as when you're in your 20s, but if you are a male and you can get to your 30s, you're generally safe. So this is the guy who did the whole, was behind the manifesto death sentences, 800 pages of screaming racial epithets at people, and was part of Nick Rekieta's Unbreaded segment. And this is him, if you've never heard him before. This is where it all came from. And you're going to say, wow, this guy's crazy, and he is. So here you go.
Touchdown, paper, unbreaded.
And he made tons of videos about all this crap. He subsequently was arrested by the feds for having a firearm in possession while he was being alone, and also getting ready to carry out threats across state lines. So he was ultimately found not guilty by reason of insanity, and the resolution to that all happened 2 days ago. Remember, I told you guys what happens when you get found not guilty by reason of insanity. The court has to figure out what to do with you. And the court has to do something. So this is it. This is kind of the last stop for Matthew Harris for a while. So it's in the District of Colorado, and it's USA versus Matthew Christopher Harris. And it's an order civilly committing the defendant to the custody of the Attorney General. So if you guys remember, there was a joint motion for an order committing him to the custody of the Attorney General, and it's pursuant to federal law. Now, remember, he had his hearing, and everybody agreed he's insane. He wasn't able to be restored by medical staff for a trial, so he was not able to be restored, so he has competency issues on top of it. So the court held a hearing on January 13th to determine whether Matthew Harris should be released or committed to an appropriate facility, having been found not guilty only by reason of insanity, to counts 1 through 4 of his indictment. And those were like threats in interstate commerce, filing a false statement to a firearm dealer. Remember, the thing Hunter Biden never got charged with. Look, we have proof it happened. Possession of an ammunition by a prohibited person. And they say, since these offenses involve a risk of substantial bodily injury or serious damage to property of others, the defendant bears the burden of proving by clear and convincing evidence. Now, remember, chat, clear and convincing is like 66%. It's like 2/3. It's above preponderance, which is like the 51% threshold, but it's below beyond a reasonable doubt. He bears the burden by proving by clear and convincing evidence that his release would not create a risk of bodily injury to another person or serious damage to others' property due to a present disease or defect. And they say for all other offenses, the defendant only bears the burden of proof by a preponderance of the evidence. So, for example, if you were convicted of or charged with multiple counts of forgery or money laundering, it's not a violent crime. But when there's crimes involving threats of violence, that you have to be you have to be fairly sure. So they talk about the underlying facts the Seventh Circuit uses, and ultimately, they talk about why the standard's appropriate. They say here there are some issues. He made threats via email of mass shootings on a college campus at UCLA. His violence towards feminists and other groups of people, basically all races. And he wanted to murder a former colleague. He had purchased ammunition in an attempt to purchase a gun. And they were aware of when he bought the gun, and that's when they went after him. And they said possibly giving him the means to carry out his threats. And the court will apply the clear and convincing standard because the facts and circumstances involve a risk of bodily harm or injury to property or another. So in September, they held a bench trial, and they found the defendant was not guilty of the 4 counts by reason of insanity. He had to undergo a mental evaluation to determine whether he would risk was harm. On December 3rd, the court and the parties received the forensic evaluation by a Dr. Tyner. from the Federal Medical Center in Springfield, Missouri. Now, what is that Federal Medical Center? When you are in a serious medical situation, chat in the federal government, you can get treated at the prison infirmary, but if it's really bad and it doesn't require immediate emergency care, like if you have cancer, like Ted Kaczynski had, he was transferred to one of the federal medical centers, which is basically a prison hospital. And in this case, he was stabilized and put in the, mental health unit there at this hospital. And they concluded that Harris suffers from a mental disease, specifically schizophrenia, such that he'd be released, he would risk harm to others and damage to property. And the parties agree the risk assessment panel's evaluation presents sufficient evidence supporting the commitment. Now, obviously, saying the parties agree, does that mean his attorney agreed? Probably, because at some point, you have to say, yes, he does meet the risk assessments, and also you have to look out for your client, and letting him loose while he's schizo is not safe for him. At the hearing, Harris waived his right to be present and to present evidence that his release in the community would not create the risk. So at that point, you're kind of agreeing to it. And they say the court agrees his release would create a substantial risk. There's overwhelming evidence that Harris has the potential for dangerous behavior if released. And they say that, going through all this, his threats focused on violent mass shooting themes at a school and made statements he would kill or torture others. He was also, they find out that some of his statements led to restraining orders being issued for a university campus and a former colleague. UCLA got a restraining order against him. He was also psychiatrically hospitalized for a brief period after being aggressive towards his mother. He purchased the ammunition and tried to buy the gun after being hospitalized. Remember, that makes you a prohibited person if you've been involuntarily committed. When the police attempted to arrest him, he barricaded himself in his apartment. So, and they say all the facts in the indictment and the government's motion for commitment convince the court he has not met his burden to show that he's not a present danger. So, anyways, they say he suffers from schizophrenia and has a provisional diagnosis of unspecified depressive disorder in accordance with the criteria set forth in the DSM-5. And schizophrenia is a chronic and reoccurring condition that is best treated with a consistent sobriety, a structured environment, and treatment with antipsychotic medications. The report notes Harris has a history of inconsistent medication compliance and the overuse of stimulant medications. So he doesn't like the schizo meds, but he likes the Adderall. They do say that there are some risk mitigations. He is ongoing cooperating with the voluntary psychiatric medications, although in the past he has not complied with recommendations to continue treatment for his schizophrenia. So, and despite his parents' attempt to assist in his compliance, he does not appreciate the severity of his symptoms if untreated, or how this can significantly impact the risk to the community, which, being non-compliant with your schizo meds would be a problem. And Harris does not have a plan in place that would facilitate his continued compliance with his medications. He says, I can live with my parents, but it's unclear whether his parents are willing or equipped to take him in. Nor is there any requirement for him to engage in professional services, and his lack of follow-through with recommended treatment in the past raises concern for his ability to follow recommendations and requirements in place. So, yeah, everything he's done before, all his medical records are being used to determine whether or not he's a risk. And he doesn't take his meds, and he doesn't follow up with aftercare. So, yeah. And I say further, the abuse of stimulant medication may exacerbate his psychotic symptoms. And the level of oversight required is unavailable for him in the community. And civil commitment will provide the structure critical to his medication regimen and prevent him from future stimulant medication abuse. And third, it's the victim's impact in making its determination. The government has been in communication with him, and the victims oppose the defendant being released and want him committed. They fear for their safety and the community safety risk. And civil commitment will give the victims in this case a reassurance that he won't kill them, which he might. He might. It's not clear he won't. So, therefore, he is committed to the custody of the Attorney General pursuant to federal law. So, in accordance with federal law, the Attorney General can release him to the appropriate state officials where he's domiciled if such state will assume responsibility for his custody, care, and treatment. With that said, though, no state will assume such responsibility. The Attorney General shall hospitalize for treatment in a suitable facility until the state will assume responsibility, or he could be released without risk of that would not create a risk of bodily injury to another. Now, a status conference will be held in July. His appearance will be waived, and the parties shall file a report 1 week prior to give him updates on the progress of his treatment. Now, that's the thing here. He's going to be committed, but they have to consistently go through and recheck on him. So in about 6 months, they'll check again. There will be consistent updates, and eventually he probably will get released. And they can only keep him so long anyway because of the crimes he committed. They can't keep him forever. Now, if they do need to do that, that's where a state government would get involved, and they can have him civilly committed. That might become an issue if he truly is off his rocker. They might have to do that, but it sounds like if he gets medicated and stays medicated, they will release him.